Welcome back, everybody, to Constructive Uncoupling, the podcast devoted to amicable divorces. I'm Judy Weigel, your host, an amicable divorce expert. Why? Because that's all I do, amicable divorces. Today's episode is the 4 steps to mediation success. The 4 steps are: choose the right mediator, learn the law, organize all of your support documentation for the mediation, and practice communication before the mediation starts. So now I'm going to flesh out each area. Number 1, choosing the right mediator. Not all mediators are right for you. In order to choose the right mediator, you should know that there are different approaches to and styles of mediation. There is the facilitative approach, transformative approach, directive approach, and evaluative approach. Mediators follow different approaches depending on the type of conflict they're dealing with. So before choosing a mediator, consider the styles and types of mediation that are available to help resolve your conflict. So I'm going to give you definitions and explanations of the 4 types of mediation. Directive. The directive style involves, as you might imagine, a more directive approach. Mediators who subscribe to this philosophy take a more active role in the mediation. They may take charge altogether, highlighting the issues they perceive to be the most important. They may also suggest solutions, emphasizing their own perspective and experience. Now, I'm taking this from mediation definitions given by a company called Gesher Mediation. I think what they did was a great job in their blog, so I want to give credit to Gesher as I read the definitions of these mediation approaches. So to continue with the directive. Directive mediators may also suggest solutions, emphasizing their own perspective and experience. Directive mediators and their experience can add tremendous value in cases where technical issues are important to the parties, but they operate in a gray area that lies somewhere between mediation, arbitration, and more traditional methods of dispute resolution, like what you would see in the litigation process when a judge is involved. Other directive mediators guard the process carefully and navigate their mediations with great dexterity. Many directive mediators are former or current attorneys with decades of experience in the courtroom. They bring with them a wealth of experience and knowledge. However, any prospective client should be aware that the process might be less client-centered. Clients should be prepared for this shift and speak if they are uncomfortable. The other form of mediation that uses attorneys and rests upon more of the legal process is evaluative mediation. So standing in direct contrast, to what I'm going to explain with facilitative and transformative mediation, we have evaluative mediation, and it's a type of mediation in which mediators are more likely to make recommendations and suggestions to express opinions. And sometimes this is really necessary. Instead of focusing primarily on the underlying interests of the parties involved, evaluative mediators may be more likely to help parties assess the legal merits of their arguments and make fairness estimates about how the mediation should end up. Now, that's when you have attorneys involved. Now, the other 2 forms of mediation are facilitative and transformative mediation. Facilitative. The facilitative style centers around the clients as opposed to the attorney mediators directing the process. The facilitative centers around the clients as opposed to the mediator and what the mediator wants to bring to the table in terms of legal understanding. A facilitative mediator will let the client drive the process, though the mediator is there to provide structure. Clients have both responsibility and power in a facilitative mediation. They need to ask questions, actively participate, and be prepared to negotiate with each other. The facilitative mediator will guide clients, but they will not direct them. The clients determine the relevant issues for discussion and collaborate to construct an agreement that meets their needs and goals. This is more of the mediation that I do. The clients must engage with each other and the mediator. A facilitative mediator should have the tools and knowledge to answer substantive questions their clients may have, but they will not volunteer this information in order to sway the clients in any given direction, nor will they offer their opinion as the guiding principle for decision making. Now we go to transformative mediation. So for facilitative, the clients decide what the topics are, the clients decide how they want to communicate, and the clients will decide on the outcome. Transformative is much like this with a little added component. So here's what transformative mediation is. In transformative mediation, mediators focus on empowering the parties to resolve their conflict and encourage them to recognize each other's needs and interests. At its most ambitious, the process aims to transform the parties and their relationship through the process of acquiring the skills they need to make constructive change. Okay, so transformative is super important in this regard, and I like to use this whenever I can. So people come to the mediation with issues. Obviously, the issues that drove them to divorce. And when they come with issues, the hope for a lot of mediators like me who practice transformative mediation is that we will construct the mediation so that the communication itself creates an awareness of A, how to look at the divorce, but how to mend their fences so that, especially if they have children to co-parent, they can co-parent in the best way possible. And I've often told a story about a mediation that I did. There were no children involved, 2 adults, children grown, and they were almost on target with dividing everything equally down the middle. But there was a sticking point, and the sticking point was the husband who had the pension to divide, and there were 2, and there was a home to divide as well, but only the husband had a pension, and then they both had this home to divide. The husband didn't want to do it equally, but he did it almost equally, but not equally, and I couldn't figure out, and I couldn't hear why he was resistant to equal. So I stopped the mediation, as it was at the end of the day anyway. Everybody was tired. Everybody went to work. On my way home, I decided to email both parties. And I said, I need help understanding why you're almost at a 50% division of the pension in the house, but not quite there. And here's what the husband wrote back. My feelings are still so hurt because I went on sabbatical for 6 months for my job. He was an attorney, actually. He went on sabbatical for his job. In that time, the wife's mother dies. The wife inherits the mother's house outright, and the wife moves all of her stuff out of the family residence with husband, not even telling him she was doing that. And when he comes back to no wife, all of her belongings gone. I mean, his stuff was still there, but all of his belongings gone. And they never spoke about it. She never explained why he didn't ask, something like that. So when he said to me he was still getting over this, which was years before they went into mediation, I said to the wife, I'm not seeing you respond to this in the email. I called her and said this. And she said to me, am I supposed to? And I said, well, yes, he just bore his soul to you. And so it does bear a response. Now, there has to be an emotional issue why the wife wasn't saying anything. And that's not my job as a mediator to figure out the emotional component. My job as a mediator is to see where the compromise is And can we deal with whatever the issues are that are preventing compromise? So they went out to dinner, I think the night after this email exchange. And they talked about it. And he shared how he felt walking into the house without her. And I guess she shared why she did it. And they called me back and they said, okay, we're dividing everything equally. We're good. Thank you. We don't need any more mediation. That was transformative. And all I did was worked off a gut feeling to ask the question, can you shed some light on why it's not an equal distribution? I need to understand this. And it resolved itself when they both got to talk. And they said it was the best conversation they had had in years. And they ended the marriage on a really positive, respectful note. So that's the cool part of transformative mediation. And in conclusion now about the types of mediation available and mediators to do it, it is vital for potential mediation clients to understand the mediation philosophy of their mediators. Mediation is an alternative dispute resolution process precisely because it allows parties to creatively construct their own solution within the scope of the law. This is an important phrase, and we're going to tackle this in a minute. Choose your mediator carefully and make the mediation seriously, and take the mediation seriously. That way, everybody wins. Now, the other part of choosing a mediator is, do you want an attorney versus a non-attorney? So I just told you in directive and evaluative mediations, really, the attorneys do that. The non-attorneys really shouldn't be doing that because law has to be quoted, and you really don't want your non-attorney mediator quoting law. It's called the unauthorized operation of law, and we should not be doing it. But some mediations benefit from an attorney mediator, especially if one of the spouses has personality disorders, and a stricter form of adherence to the law is necessary, and that's when you really need an attorney mediator. An attorney mediator maybe is not the best person, by and large, to do facilitative and especially transformative. It's just not how they're typically trained. They're really trained to stay with the law, and they do earn their weight in gold when you have a couple that needs that. So I have referred attorney mediators to my couples on several occasions. And one of them was the wife was such a severe alcoholic that she had one of these systems attached to her that if she took a drink would buzz and go to whatever counselor it was supposed to go to. And she absolutely wanted to disregard the law completely and do exactly what she wanted to do. Yet they had to get through this. So I gave them an attorney mediator's name and number, and he actually did the trick. He actually got them to resolve. But he stuck with the law because they needed it. They were not the couple that could creatively put the law aside and do something mutually beneficial to both of them. Now, lastly, both mediators, before you select a mediator, both spouses should speak with the potential considered mediators before scheduling a mediation. Both spouses. And generally, I speak with both spouses. Generally, most mediators speak with both spouses. But once in a while, one spouse doesn't even want to do the advance work. Just schedule the mediation, I'll be fine. I'll take the mediation if that's what their decision is, and then I'll spend a little bit of time talking to the person who didn't call me first, because I really want them to understand mediation. And I'll read the contract out loud to both of them, even though I send it ahead of time, so that they can absorb it in the privacy of their own home, in their own time, make notes, see if they want to ask me any questions. And when you interview mediators, it can be on the phone. It doesn't necessarily have to be in person. And I'm one of those weird mediators that prefers the phone. I find for some odd reason, I do better work on the phone. I don't want the mediators to be distracted about anything. My office is beautiful, so you're going to come to a lovely setting when you come here. I am a lovely person. I always dress professionally. You see my pictures everywhere on social media. You have pictures of my office. The reason why I like to talk to people on the phone is because there's an intimacy to it. And I speak to each spouse individually. When you go to a mediator's office to interview them, you're together. And it doesn't give you the space and the personal time that I think is very important when you're interviewing a mediator. So that's why I like to do individual talks on the phone, very personalized. I almost don't put a time limit to it. They generally go from a half an hour to an hour, and I'm okay with that. I want everybody to feel comfortable when they're done with their conversation with me. All right, so number 2. So that was the first step, choosing the mediator. Number 2, learn the law. I cannot impress upon you more how important it is to learn the law. In my opinion, every single person should consult with an attorney before they file for divorce in order to know the law that supports the division and distribution of your assets and debts, spousal support or alimony, as they say in other states, child support, custody, and the co-parenting schedules. You should not make your mediator responsible for teaching you the law once in a mediation session, or you will take the mediator out of a neutral position. And one spouse will inevitably think that the mediator, in quoting the law, is siding with one spouse over the other, especially if that spouse has a distrusting nature to begin with. But the forms of mediation that are better suited to an attorney mediator, the evaluative and directive approaches, are for valid reasons. The parties cannot make decisions mutually because of reasons like their inability to listen to each other's needs, their inability to accept the law, personality disorders that may prevent them from focusing on the realities of their settlement, or any other reason. Mediation is an issue of compromise, and both people have to come to the table willing to compromise. Everybody's definition of compromise is different, of course, but mediation is an issue of compromise. So seeing an attorney is not being disloyal to your spouse. It's the smart thing to do, so that if you and your spouse decide not to divide anything in the course of the mediation and choose no spousal or child support, you're doing it with informed consent. Informed consent means that you've been informed by a legal professional, an attorney or a retired judge, to understand your state's laws and to understand your legal rights. You have been fully informed as to your legal position with your assets and debts, and if you choose to do something other than what the law provides, you're doing it with foreknowledge, and only an attorney should do that for you before the mediation. And even if you get a separate attorney to tell you what your legal rights are before the mediation and you still choose an attorney mediator, now you'll know how to ascertain if your attorney mediator is right. I'm telling you, attorneys, mediators, we're all human beings. Everybody makes mistakes. And you're going to hear sometimes by interviewing attorneys that you're not going to get the same exact answer from every attorney. Believe it or not, you're not. You're going to see gray areas of the law, and you're going to see attorneys interpret the law slightly differently sometimes. And so what I said earlier was sometimes people have to use an attorney mediator because one or both spouses need an attorney to keep them aware of the law in order to keep the negotiations focused and moving forward in a way that a settlement can be made without a trial and a judge making the settlement decisions. But before you even see an attorney, go on Google and type in the Google search bar, whatever your state is, followed by the words divorce laws. Get acquainted with the laws as they affect your settlement so that you can have the best conversation with an attorney possible. We go to number 3. Organize all of your support documentation for the mediation before you enter the room. You will be negotiating the division or distribution of assets and debts, alimony and or spousal support, the co-parenting schedule, and child support. These are the basic areas in a divorce mediation. In California, we have what we call disclosure forms. They're used for a listing of assets and debts and to show you income and monthly expenses. They have to be exchanged between spouses. This is the centerpiece of where the agreement and decisions are going to come from, the disclosure forms. There has to be something similar to California disclosure forms in every state because the point of divorce is to separate each spouse financially from the other by dividing what was accumulated during the marriage and to equalize the standards of living between spouses through alimony/spousal support with a financial disclosure form. The co-parenting schedule in California has to be established first before child support can be determined. And the reason for this is because the percentage of time that the children are with each parent is a determinant in the calculator for child support. Unless both spouses can verify the value of their assets and debts, now verifying means validating through those support documents. Paper trails. If you have, for instance, a house and it was separate property before the marriage began and now it's community, there's all of the support document to show how much of the house financially is separate versus how much is community. So again, both spouses have to verify the value of their assets and debts so that each spouse is confident that the numbers being used are accurate. The settlement agreement may be challenged after the divorce is final if it's not. Seriously. Once the settlement agreement is written and sent to the court and signed by the judge, that's when people start having decision-maker remorse. That's when people are calm enough to really go back through their decisions and say, wait a minute, I just made this decision too soon. I'm not happy with my decision. Or, oh my gosh, I just found some paperwork that I should have had for the mediation, and it would have changed the numbers for dividing some asset or debt. Who knows? This is why you have to be very thorough and bring all of the support documents to define the value of the assets and debts so that you can have a profitable mediation. Your mediator won't be able to help you in the best way if the mediator doesn't have all the information to use in the mediation. Although some people like to mediate before they file for divorce and before they establish two households, understandably so, another look at the settlement in these mediations after the disclosures are exchanged and the filing has begun will typically be reevaluated once the disclosure forms are exchanged to fine-tune the settlement. So I do enough mediations, and so do other people, before they file for divorce because people like to lay out the groundwork. They like to be clear about what's going on. They don't want any surprises, and that's fine. And so I explain, okay, go online. Here are the disclosure forms we're going to use. Look at the assets and debts. If you have a prenuptial agreement or a postnuptial agreement, bring it with you. And then we'll go ahead and do the best we can. And we'll do a mediation agreement. We'll file. And then when we exchange the disclosure forms, we will make sure that your numbers were right. Everybody wants to do that. And those who don't are... you can do what you want to do, but trust me, someone is going to speak up and say, well, wait a minute. These numbers are different than we talked about in mediation. I think we should go over this again. It's going to happen. So do the best you can prior to filing if you are the couple that wants to kind of lay things out first. But get ready to fine-tune just so it's done in the best way possible and nobody regrets once the decisions are made and the judge signs off, and set yourselves up so you don't have to revisit this. That's my message. Mediation, as I said earlier, centers around compromise. Put with all of your organization and support documents, put in priority order the issues that are most and least important to you. This will be your guide when working out the settlement terms. Don't overreach, or whatever is agreed upon in the mediation will fall apart once the divorce is final. Remember, some people tend to agree to things they don't want just to get the process of divorce over. It's that painful to them. So, overreaching. I can clearly see when one spouse has not counseled with an attorney or gone on Google and learned about divorce laws, because they will ask for things that would never, ever, ever, ever be granted in a court of law. They just ask for everything. And you can't ask for everything. Nobody walks away with everything. Divorce is a division or a distribution of, depending on your state and how they approach the settlement agreement. But overreaching is a waste of time. And if you're of the mind that you have to ask for the moon and go lower, it doesn't work in mediation. It really doesn't. Get to the business of working within the law or slightly around the law, because you're going to waste time and money shooting for the moon because you're going to get shot. It's not going to work. But to my point, remember that some people tend to agree to things they don't want just to get the process of divorce over because it's so painful. It's going to factor negatively. So, lastly, number 4, practice communication before the mediation. Communication is at the heart of the discussion and negotiation in mediation. Good communication is essential to a successful mediation. When we're fearful, when we're angry, and when we still blame our spouses for the reason for the divorce, as we see it, of course, we won't communicate well and will destroy the good spirit that has to be part of a beneficial settlement discussion. Don't bring up the hurts and reasons why the divorce is taking place, unless there are substance abuse issues that will affect co-parenting. When it comes to the children, everything that might adversely affect them has to be discussed, especially substance abuse or things like gambling or a penchant for pornography. This seriously has to be presented in the most delicate way. You can't get angry about it, either spouse. You can't get angry. And I know it's hard. But you have to practice speaking in a calm voice while looking your spouse directly in the eyes and explaining how you would like your spouse's abhorrent behavior to be addressed in co-parenting. If your spouse hasn't contributed to the acquisition of assets or has been responsible for extreme debt because of substance abuse or an inability to provide income consistently during the marriage, discuss this with compassion and understanding, while firmly and pragmatically asking for what you would like. Blaming will kill you in a mediation. Bringing up adultery will kill you in a mediation. Bringing up anything other than substance abuse or anger management, emotional issues, because you now have a third person in the room that allows you to vent, it's not going to work. It's going to bite you. I have had people walk out. I have had the party being bludgeoned and spoken about just walk out and say, this is not what I signed up for. And I understand it. Mediation is not the opportunity to embarrass the other person. But when it comes to the children, you have to discuss things that may harm them, because you are equally responsible if you're the parent that doesn't have these issues. Practice before the mediation starts how you want to communicate what you would like the settlement to be. The way in which you communicate what you would like matters so much. Get all attitude out of your voice. Remove superiority, remove blame, remove arrogance, remove the temptation to diminish your spouse's value through a condescending tone of voice. Mediation isn't therapy. It's not an opportunity to shore up emotions and express all of the hurt and anger in front of a third party, the mediator. Mediation is more like a business discussion about money and financial values, but it's also about the sentimental value of things that you have both acquired. It's one of the hardest conversations you'll ever have, other than telling your children you're getting divorced. Yet, it has to take place. Sometimes people start the mediation process and can't finish it for a year or two until the emotion diminishes with time and they can get on with the business of dividing money and stuff. You have heard me discuss in previous mediations that there are two divorces. There's the emotional divorce. In other episodes, you've heard me talk about this. There's the emotional divorce and there's the logistical divorce. And until you deal with the emotional divorce, the logistical divorce will be very difficult. So how do you do that? You spend time either going to therapy or just letting time go. Establish two households maybe, or within the same household. Just work on getting rid of the anger, getting rid of the blame. Just work on talking to one another and forgiving each other, because we're all imperfect people. We all make mistakes. And at any given point in time, we're doing our best. And sometimes our best just isn't all that good. But we have to get through the emotional divorce before we do the logistical divorce, or it just will be a struggle and it'll take forever. And if you're both being represented by attorneys, you'll spend so much money that you don't have to spend. So trust me on that one. Emotions come first, logistics come second. Practice being, back to the communication issue. So practice being silent and listening to your spouse without interruption. I know you know what they're going to say before they say it, anticipating the same old story and possibly untrue versions of the story that drove you apart. Just listening makes your blood boil and you erupt. What you're listening to is crazy making, and God forbid the mediator actually believes your spouse. Okay, so this is why choosing the right mediator is important, with the right style of mediation that is better for your specific situation. You need to trust that your mediator will guide conversation properly. So listen. If I had a penny for every time somebody said, I'm just afraid you're going to find him or her charming. Everybody finds him or her charming. And my response is always the same. What you find charming, because you initially fell in love with your spouse, trust me, I'm not going to find charming. I'm not looking for charming. Mediators generally are not swayed by the way somebody speaks unless it's adverse. What we listen for is compromise. What we look at are numbers. And what we want to do is get you both to be on the same page to make decisions that work for both of you. Most good mediators are not going to be swayed by what you consider to be charming. That's you. You're coming from your own personal prism and perspective. We don't know you. We don't know your spouse. We know our jobs, and we know what we are to do to help you come to a mutual decision. Let your mediator do what they are there to do. Wait until the stories are told and then move the negotiation back to business. Your mediator, the longer somebody mediates, the more they will jump in at a certain point and cut the story down, because the story will be filled with things that are not really relevant sometimes, because that's how stories go. And I think a really good mediator will know when to say, I understand this is important to you in reflection and maybe should come out in therapy, absolutely. But right now we kind of have to move this to logistics. And we gently do that. But this can only happen if you remain silent until it's your turn to speak. So practice at home. Practice listening to everything that you want to strangle your spouse for. Just Recreate what you think your spouse is going to say and practice being silent. Just practice. And then it will be your turn to speak. Don't say, are you done now? Is it my turn? Okay, that's called attitude. Don't do that. Just be silent. And when it's your turn to speak, speak. And your mediator will turn to you and say, it's your turn to speak. They really will do that. You don't have to worry. And if they don't, and if for some reason you have a horrifying mediator that is not even looking at you or listening to you, you have every right to get up and walk out. You are not required to stay there. And you can say to your mediator, I think you're being partial. I tell all of my mediation clients to do that. I say, please speak up. If you for some reason think I'm not being neutral, I need to hear it. Do not harbor that, because maybe I don't even know that what I'm saying could be phrased a different way. Most of us are there to help you. We're not there to hurt you. We really want you to settle. It makes us feel good when you settle. So please let your mediator know when you're feeling uncomfortable about either their reaction, their way of guiding the conversation, and the length of time they're letting their spouse talk. But I'm telling you, the gold is in listening. When you listen and not interrupt, which is so rare for anybody to speak without being interrupted, I have watched people change their minds as they speak and say, you know what, maybe I'd be willing to do this. Honestly, that's how important it is not to roll your eyes, not to do facial gestures, just to listen and allow your spouse to speak. You do not have to correct them while they're speaking. You can tell your version of the story when it's your turn. You must trust that your mediator will keep moving you both back to the relevant part of the negotiation. And if that doesn't work, change mediators if you see that the one you have isn't helping the settlement move forward. Don't be shy about speaking up and asking for what you would like. If you know the law, it will help you request terms close to the law and not overreach. Overreaching generally isn't accepted by the other party, at least not permanently. When one spouse has a hard time getting their needs met in the marriage, or is used to stuffing their feelings and desires for the sake of avoiding an argument, that spouse can easily fall into the same pattern in the mediation. Practice what and how you want to communicate. If you're the silent spouse, because you now have a neutral third person in the mediator who will allow you the space and time to do what you have found it hard to do in the marriage, and that's speak. And lastly, in this section on communication, there is an aspect of the mediation called a caucus that can serve the silent spouse well. In a caucus, each spouse is in the room with the mediator by themselves. This separation of spouses will support the silent spouse in speaking their mind without worrying about the other spouse making them feel diminished and unimportant. I also use the caucus when I think that spouses are both holding back what they really want to say, not to make decisions for them, but to let each spouse speak uninterrupted, to learn as much as possible about what each spouse truly wants in the settlement and what they're willing to give up, so that I can see where the compromise points are and help communicate that to the other spouse. So what happens a lot of times in mediation is people don't hear where the compromise points are. First of all, they don't speak their minds. They hold back. They're afraid. And when I get them in caucus, they can speak freely to me because it's confidential. And if they tell me I don't want you to repeat this, I don't repeat. So I let each spouse speak without interruption in caucuses, one-on-one, and I ask questions. Sometimes I'll ask for a caucus because I want to ask questions that I want the person to speak freely. I don't want them to hold back, especially if I think they're holding back because they're afraid to speak their mind. And generally, I'm right. I've done this enough to know when I need to speak to each person individually. Once I share, they have to allow me to share. Once I share what they couldn't say in front of each other, or help them put communication together so that when we get back in the room, they have better tools of communication to use to say what they want to say. We generally come to compromise. Generally. I say generally because, of course, nothing is complete, nothing is finite, or nothing is infinite. But those caucuses are so important because people, when they're talking, are so filled with their own fear and what they would like, sometimes they don't hear, even listening to their own spouse, where their compromise might be. Or because I've done so many mediations, and the mediator you're going to use is versed with so many different examples of creative settlements, they can actually say, well, listen, I was working with one couple that had a similar situation, and this is what they did. So you're not really telling them as a mediator what to do. You're using real life examples to present to people that can either maybe be accepted by them or used as a starting off point for another compromise that may be specific and useful to them. So that's what I have to share with you in this episode about mediation. So let me just go over the 4 points again. You must choose the right mediator. You must learn the law. You must organize all of your support documents for the values of assets and debts before you go to the mediation. And you must practice communication before you get to the mediation so that whatever you say will be accepted and you have the greatest chances of success. I thank you so much for joining me on this episode of Constructive Uncoupling, the podcast devoted to amicable divorces. I'm Judy Weigel, your host and amicable divorce expert. Please subscribe to this podcast by hitting subscribe on Podbean. You can go on Apple, Spotify, Stitcher, and do it there. If you would like to give me any ideas for mediation topics, you can email me at Judy, Judy, at constructiveuncoupling.com. Judy at constructiveuncoupling.com. And don't forget, have an amicable day.